Welcome, everybody, to the launch of the first issue of the African Journal of International Economic Law. We are delighted that you're all here. Just a few housekeeping rules that the president, that's Bisi, although there's also President Amaka here, asked me to announce. So keep, I think we are all aware of this now. Please keep your mics on mute so we can hear each other. And then, we don't expect to be more than an hour for the former part of this, although everybody is welcome to stay on after this and sort of have informal conversations. We are also recording the launch, just so that that you know. And feel free to use the chat function as well. It's open. I know that BC, my co-editor-in-chief, will confirm that we are truly humbled by your presence and support. This journal, like AfronomicsLaw, its sibling, has been an effortless labor of love for the last 2 years. And this launch is really about gratitude. We are really grateful to our terrific authors for agreeing to publish in an untested, primarily online journal. We are really delighted to have the support of our editorial board, Claire Gamage, Regis of University of Bristol, wave wherever you are. Regis Simo of WITS, University of Witwatersrand, Caroline Sube, I know I mispronounce that name every time, Tsotang Tsetse, who has just finished her PhD at the University of Cape Town and teaches at the University of Lesotho, Ibironke Odmosu Ayano of University of Saskatchewan, Amakavani of the University of Leeds, our advisory board, and I see our advisory board members here, Anthony Ange, Sergio Puig, Anthony Ange, of course, of University of Singapore and University of Utah, and the Third World in general, Sergio Puig of University of Arizona, Danny Bradlow, University of Pretoria, Jan Yevis Remy of the Sri Dath Rampal Center for International Trade Law and Policy and Services in Barbados, Heja Gueldich of University de Carthage, Tunis, Francisca Saka of University of Witwatersrand, Joy Kategekwa, one of the architects of the Africa Continental Free Trade Agreement, formerly of UNCTAD in Addis, and now at UNDP Africa in New York, and Marcus Wagner of University of Wollongong. Sorry for all the mispronunciations. It's sort of very traditional Third World. So we thank our audience, the AfronomicsLaw audience. Our readers and contributors, you're the reason that this journal has come into being. We thank our terrific editors and our contributing editors who put a lot of energy to this enterprise. I just want to mention here Ohio Omiunu, who does all the amazing posters that you see, sometimes like within an hour of sort of an idea, a crazy idea we have, and he comes up with a poster while teaching 1,000 students especially this fall. The African International Economic Law Network and its members, and all the institutions and partners that we've partnered with over the last 2 years. Too many to mention, and I don't want to risk missing out anybody, so I'll refrain from trying to list all of them. We thank our respective schools. We thank Almond Print Limited in Nairobi. We thank our respective families, especially me and BC. I think our families have virtually merged. Anytime my phone rings, my daughter knows to ask, is that BC? to the to this brilliant and tireless BC. I don't know how many BCs there are. I discover new things about him every day, including things that he has written I didn't know, although I speak to him every day. Now, of course, all the articles are now live and freely available on our blog. And I think, BC, have you shared the link with everybody? So the African Journal of International Economic Law is free. It's open access in a truly free version. We are not hiding the ball. So we ask you in our audience to make sure it reaches every law school or institution that teaches international economic law, especially in Africa and beyond. I must mention here too, another thing about Ohio Munu. He is responsible for Academic Forum, a really vibrant academic forum. We started with the East African region, and the students from Nairobi have really been putting Professor Munu on the sort of spot, asking him why he's teaching in the UK as opposed to being sort of in Nairobi or in Lagos or somewhere in Africa. These students are really terrific, and we are delighted that there's a generation of international economic lawyers in African universities that are really our primary audience. They're not the only audience, but they are our primary audience. So like I said, the mission of this journal is very simple. It's to fill a gap in international economic law scholarship in Africa and in the global South. As we know, there's lots of terrific journals on African international law, especially public international law, international criminal law, but there really hasn't been a journal that sort of focuses on the issues of international economic law. The genesis of this enterprise, the journal and Afronomics, is very simple. I was driving one day from work and I called BC and I was very, 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 very frustrated. This was 2 years ago. The only news and anything anybody wanted to talk about in international economic law, at least it seemed to me and BC, as I discovered in that phone call, was Brexit or the trade wars between the US and China. There was just no airtime for anything around the issues in this journal. It was the time when the Africa Continental Free Trade Agreement was the conclusions of that agreement were happening. It was a time when there was lots of discussions about the future of the Africa, the African Caribbean, the APC, the ACP, the African Caribbean Pacific countries sort of agreement with the EU, the Cotonou Agreement, that Clay is an expert on. So many things were happening, but those things were not being discussed anywhere. And we just wanted to start a blog to start discussing, even if it was just me and him. And so the amazing support we've received from everybody since then is what has led to this journal. So our mission is to be inclusive. We sort of have been delighted to have collaborators from many places in the global South and elsewhere, and we hope to continue to do that. So we are an extremely young journal. We certainly have made many mistakes, and I think our authors will confirm that. Me and BC in particular and the editorial board take total responsibility for all the missteps and the mistakes and the lack of elegance and all those things. But we totally believe in the quality of what our authors have produced. I don't have much more to say. We are really proud of what the authors have done. And I want to pass this on to BC, because then after that, each of the authors will tell us about their really, in my view, groundbreaking articles. And I mean that very sincerely. So BC.
Okay, thanks a lot, James, and thanks everyone for making the time out to join us. Really, as James said, this is a humbling experience, and at its heart, it's to say thank you to this community. I think the first thing I want to say, and perhaps repeat it, perhaps overwhelmed by the moment, is Afronomics law is because you are, because of our readers, because of our authors, because of our supporters. Well, I'm getting teary-eyed, actually. And so, okay, sorry, okay. Okay, sorry, I can't do this, sorry.
I can tell you the reason that BC is very overwhelmed is because his article was initially rejected by the journal, and he spent sleepless nights. He can't believe it finally got published. So, so BC.
Okay, so it's I think the continent is close to our hearts, and whether you live in the West or on the continent, I think we'll find it's to say thank you really to everyone who has given to this moment. We are not gatekeepers. I think some of you have heard that, and I'll state shortly. What I want to just say to everyone is this platform is not about choosing who's the best author, who's the best writer. It's to lend hand to many who have been left on the side. And, to be a part of that and to see the trust that you all have given us and continue to give us is really a blessing. So thank you very much. I think the authors are terrific. Thank you so much for heeding the call, and I'll turn it over to James. On the other end, I'll say the other things that I need to say, but thank you.
All right, thank you so much, BC. You're amazing. Now to our amazing authors, we don't want to sort of keep this study to ourselves, and we'll begin with Claire and Marion. They'll tell us the title of their article, what why we should read it. All right, so there you go.
Okay, good morning or good afternoon, everyone. My name is Mira Molafi. I'm a PhD candidate at University of Toronto Law. And before I go into talking about the article that Claire and I wrote, I'd just like to say a few words. First is to say thank you for this opportunity. The first time I met Dr. BC, I called him out of the blues, or he called me, we connected on LinkedIn, and I was crying about how impossible my PhD was going to be. And I would say that since I've been connected to this community, it's been such a fantastic community of support and mentorship, and the work is greatly appreciated. So it's a huge honor for me to contribute to this journal. And just to keep this within 2 minutes, I would say that it was a pleasure as well working with Claire on this article. Our article is titled The Economic Empowerment of Women in Africa, Regional Approaches to Gender-Sensitive Trade Policies. So a little bit of background. When Claire and I first connected, it was clear that we had a couple of areas of interest that overlapped. And the first was women, regional integration, development, and how basically it was clear to us that when trade law was being discussed, specifically in Africa, it was usually discussed from a very holistic perspective without paying specific attention to the issues that women face trying to access markets, or even just trying to succeed as, with international trade. So it was a big endeavor to basically try to speak up, I guess, about the issue. And one of the things we decided to do was to take a blend of approaches. So we took both a historical dimension. We also had a comparative element to our work where we looked at the trade policies in the different regional economic communities in Africa. What exactly is on board? We also had a critical dimension to the article. So one of the major themes of the article is that the distributional effects of trade law, feminist scholars have said this for a long time, that the distributional effects of trade aren't, women tend to be the shorter end of the stick. They tend to have a very small piece of the economic pie. And for us, the question was, how can we look at trade laws that are seemingly neutral and show that they have a disproportionate effect on women, and particularly women in Africa. So to do that, we first of all took a historical dimension and looked at how, trade policies on cocoa and adire. Adire is a tie-dye fabric that is commonly produced in the southwest part of Nigeria and some other African countries. But we used my hometown, no bias, Abeokuta, as an example, as well as the cocoa farmers in Ghana. And what we found out was that, policies encouraging farmers to grow cocoa for exports had different effects in Ghana and in Nigeria. In Ghana, women were able to tap into the market because of the cultural nuances there, while on the other hand, in Nigeria, women were excluded from the market. So these policies appeared neutral, but had different effects depending on the context. We also looked at adire, the tie-dye, the textile makers. And at the end of the day, we found out that expanding the textile market or opening up the textile market to competition in Nigeria essentially killed that very traditional, rich industry without a proportion, without trade adjustment policies to cater to the women. So it just shows that from time immemorial, trade policies have had disproportionate effects on African women. And the situation is pretty much the same today, particularly when you think about informal, women in the informal economy who are trading as well. So I'm going to hand over to Claire to just talk about the comparative dimension in terms of how we looked at the regional trade agreements, as well as our recommendations for the African Continental Free Trade Agreements. Thank you very much.
Thank you. Thanks, Mariam. And just to say, Mariam was a fantastic author to work with. We've actually never physically met one another, so this is the first project we've done together. It was amazing. And as Mariam has said, this was part of a broader discourse that we're both really interested in, which is around the shift towards women's economic empowerment at the World Trade Organization level, for example, and the International Trade Center. And as Mariam says, we wanted to see and contest this idea that trade is gender neutral and in fact show that trade is both gendered and gendering. And so we wanted to do that by looking historically, as Mariam has said, at the African continent, and to kind of disrupt the narrative that women's economic empowerment in trade is a new thing. And we wanted to show that actually this is an idea that has been present on the African continent for a very long time. So we did this comparative analysis of the different regional economic communities. We looked through each one to see its treaty basis, to see where women featured. And unsurprisingly, they featured as a part of a broader development discourse. And that ties in with today this idea that women and gender are part of this sustainable or inclusive development agenda. And what we found on the African continent, unsurprisingly, is that gender is not treated in a homogeneous way across these regional economic communities. It's treated very differently from one initiative to the next. But we also came across some really interesting policy-based initiatives that sit sort of as soft instruments alongside the legal treaties that help to enable informal cross-border traders, for example, who are predominantly women, to continue trading and to access economic benefits. I suppose for me personally, my concern with this work comes from a fear as an intersectional feminist around the co-opting of language at the WTO of women's economic empowerment and gender mainstreaming. And so it was really interesting doing this project to see how prominent gender actually has been within the legal frameworks and the discussions for many years in Africa as almost a response to the feminization of trade and the feminization of poverty. But what Mariam and I found, again, unsurprisingly, is that in reality, there are significant social and cultural norms across the continent that prevent the realization, perhaps, of more gender-friendly opportunities from arising. So we conclude by saying that if the AfCFTA is to embed a gender dimension into its framework, it should learn from the histories, the good things and the bad from the regional economic communities, But I think it's fair to say we remain sceptical of a uniform approach being taken at the continental level. So I shall leave it there. And just wanted to say as well, thank you very much to James and to BC for giving us this opportunity to showcase our work. We're really, really excited. You know, it's a real privilege, so thank you.
Well, you're too kind to thank us. We are the ones who are really grateful for everybody's willingness to experiment, to go on this experiment with us. So thanks, Claire and Mariam. And now we are on to Tim and Vela. So, you know, we are going by the African 3 minutes.
I shall try to take less than half of that. It's a real pleasure to be with you. Thank you so much. It's a great honor. I've been interested in the drivers and consequences of the global spread of competition law and policy for quite some time, and for lots of reasons. The African continent, as well as, of course, many of the individual countries within Africa, have been of special interest there. One of the reasons why I think Africa is so particularly interesting is because it's the only continent, the only region in the world where multiple regional arrangements for competition law and sort of more broadly the regulation and governance of market competition through law and policy means coexist in partial overlap, which creates political as well as, of course, economic dynamics that are, I think, of interest and importance to many parts of the world. But Africa is really the only place where we can study this in a broadly comparative context. So that was kind of the backdrop of my intellectual interest in this project, which was further sort of stipulated by having about 4 years ago been recruited from Duke University, where I used to be on the faculty for about a dozen years, after a total of 25 years in the United States, to actually return to what originally was my native Germany, when the Technical University of Munich launched a new social science, political science and public policy unit and brought me onto the faculty here. And one of the quite unexpected consequences of moving from the US back to Europe, maybe it's just the geographic proximity, but the sort of awareness of the incredible dynamism of so many parts of Africa seems to be, I think, considerably higher, at least in many parts of Europe, than frankly I ever experienced in the US. And so it was in that context that about a year and a half after I had arrived in Munich, Vela contacted me, at that point working for the Kenyan Competition Authority, soon after having completed her second law degree, and expressed interest in coming to Munich to work on a PhD. And so for the better part of, I think, 3/4 of a year or so, certainly about half a year, we exchanged emails and occasional crackling phone calls to try to develop sort of a research agenda that would be not just interesting and feasible as a PhD project, but also allow us to apply for funding to enable her to be here in Munich and work on her PhD. And this invitation that James and BC very kindly issued for us to contribute to this inaugural issue of the journal, after we had contributed to a book review forum about, I guess, almost a year ago, was really a wonderful opportunity to sort of engage in a bit of stock taking, both in terms of some of the work that actually Vela has done as part of her PhD research over the past year and a half, 2 years, but also more generally, of course, engage in a bit of stock taking in the many interesting developments at the national level and at the regional level in the governance of markets in Africa through competition law and policy. And I'll let Vela elaborate on that a little bit.
Okay, thank you so much, Professor Tim Bute, who is my primary supervisor. It has really been amazing working with him, and the fact that our institution is a political science institution, and I was coming from a legal background, so it has really been some difficulties here and there, but it has really put me at par. So this our paper. We decided to provide stock taking of the national competition laws in Africa and also the regional competition regimes. It was informed by the reality that research, scholarly work on competition law in Africa or developing countries in general is really scarce. And even when it exists, an empirical analysis or evidence-informed research is rare. So we decided to set out a research agenda so that we could attract other scholars who could venture into this amazing project. So initially we set out the research agenda for national competition laws, and we wanted to first of all understand not only countries that have established competition laws, but of importance is also understanding countries that have not established competition laws. So for this particular case, what we are trying to push to push on is the realization that if we are going to talk about competition policy in Africa, then we are going to talk about the history and the evolution of these competition regimes. And also, Africa also provides another exemplary context in which you can also understand regional competition regimes, because African regional integration is based on regional economic communities, and we have so many of them. But out of all these, 7 of them have regional competition regimes, but even the models which they adopt also differ across these regional competition regimes. So for example, we are having regional competition regimes that what we refer to with Tim as confederate, which only provide a cooperation framework. And this includes the SADC, the Southern African Development Community, and also the Southern African Community Customs Union. And also we have other 5 which now provide competition laws and rules that are binding in nature. And when we look at these 2 regimes, Africa also provides us with an avenue in which we can understand which of these regimes is more effective than the other one. So we hope that this paper is going to provide groundbreaking research for African competition laws. And more important, we are not looking at competition law just as a legal aspect of economic law. We are also looking at the political analysis of these competition laws. For instance, when we talk about jurisdiction conflicts between a regional competition regime and a national competition agency, for example, the case of the common market for East and Southern Africa, these jurisdictional conflicts are not, it's not a legal issue. It's an aspect of political willingness of national competition agencies and also the member states in implementing the laws that they did inform. So what we are driving, and as I finalize, is the need to go beyond law and look at the political analysis, look at the economic factors, look at the social factors that are driving competition law in Africa, and also look at the dynamics of African markets, including the impact of COVID-19 on African markets and also the digital markets and the impact of technology. Thank you.
Yeah, thank you very much. This is a really terrific article, just like the first one. I just want to say that the 2 first articles in the journal, we intentionally wanted to link these senior scholars with emerging scholars. And I personally believe, and I think BC personally also believes, that creating these types of relationships is crucial for career trajectories, but also for developing the scholarship. So I see one of my mentors here, Tony Angi. I couldn't be here without Tony, and that's a long story. But I just want to say that we are really committed to making this the kind of place where we promote this kind of scholarship that would otherwise not be possible. I want you in particular to also look at the graphs, on pages 49 and 54. There's some colored charts that Vela and team prepared. And they did a lot of, I can tell you, they did a lot of painstaking work, not just so that they could look good, but also make sure they are accurate. This is really original stuff. And so we thank them for trusting us with this stuff. I think, Tim, I see you want to say something about that?
Well, thank you for having managed to actually allow us to have colored graphics in the journal. Initially, I was concerned whether that would create cost problems or otherwise would be hard to do. And it, of course, makes the visualization of information, I think, so much easier. So I just want to say thank you for making that possible.
Well, you're very welcome. We thank Almond Print Company in Nairobi for making this possible. The other thing I was going to say is that, as you can see in that relationship, there's sort of the scholarship and the practice dichotomy that we also want to break down. We also have Danga coming up soon, but before that, we have Taimon Stewart from, she'll tell us where she's from and what her paper is about. It's sort of related, very related to the paper we just heard about. You're on mute.
Sorry, thank you. So thanks, James and BC, for all the support you gave and for inviting me this. But particularly, I want to thank Jan, because it was through her that I first got connected to this family, to write a blog, a contribution to the blog on a book written by Professor Eleanor Fox and Moore Brockham, on making markets work for Africa, markets development and competition law in sub-Saharan Africa. And this is a recent book, and on reading the book, I really was taken by the fact that for the first time I was seeing a deep political economy analysis taken by these authors in evaluating competition law in sub-Saharan Africa. And my original discipline is international relations, political economy. And so I was immediately drawn to this analysis. And it struck me there was certainly many similarities in the kind of issues that they brought up, similarities between CARICOM, which is a Caribbean community, the integration group within the Caribbean, and sub-Saharan Africa, but there were also significant differences. So having done the blog, which was just a couple of pages, I went on to start doing research and doing a comparison just out of my own interest, because I was so keen to show that there was actually some significant similarities, all based on colonialism and imperialism. And so both Eleanor and Moore's work and my work delved into the history of these countries, the imperial, the colonial and imperial experience, and how this impact on the current situation. And in the case of the Caribbean, and so my paper is about a comparison between sub-Saharan Africa's competition law experience and the CARICOM experience. And my first recognition is that whereas in Africa, imperialism and colonialism was brutal, destroyed social institutions, destroyed economic institutions, etc. But there still is a retention of the original culture and original society, the original people. But in the Caribbean, it was completely wiped out. So it was started from a blank page. And everyone in the Caribbean was imported. We are all transplants from so I am as you may see, I'm of East Indian origin, but I'm from Trinidad and Tobago. And the population of Trinidad and Tobago is like 40% of East Indian origin, was 38% African origin, and then a mixed match of other combination of races, plus less than 1% of whites, Syrian, Lebanese, and Chinese. And yet the whites and Syrian Lebanese control the economy. So all of these things began to really strike me as when we try to define or describe markets, for instance. The general description is, well, in the Caribbean, it's small economies, you must have concentration, and because of economies of scale, because you import most products, but nobody has delved into the fact that those concentrated conglomerates can be traced back to the 1800s, when the majority of population had just come out of slavery and when the Indians were still indentured laborers. So what market opportunities were there for them? So those concentration exists today still, and they can be traced back to the privileges derived from colonial times. Another point that became very clear is the whole issue. I mean, we have been saying again and again, you cannot transpose a law from the north, from industrialized countries into developing countries. But in most cases, the laws have been imposed as part of structural adjustment programs. And the countries that were receiving these laws had no idea what these laws were about, nor were they really shaped to the needs of those economies. So all of these issues were raised, and in Eleanor and Moore's book, they propose several ways in which the laws can be simplified, can be enforced in a way that will be more suited to those economies, etc., and very path-breaking. I think that there's a lot more work that still needs to be done on how we now take these laws that were imposed and then reshape them to the actual needs of the economies that are receiving them in the context of the colonial impact on those societies that are still alive and well, and also the institutions that were shaped by colonialism that still function in many ways in support of the political and socioeconomic advantages derived from colonialism and to the disadvantage of the masses of the people. I think that kind of sums up what I did in the book. In the paper. Thanks, James and Missy.
Great. Thanks so much, Simon. We are delighted that your paper complements very well the work that team and
Yes.
Bella are doing, and that, as you said, it's really the first book on competition law in Africa, written by Professor Eleanor Fox and Mo Barkham. So we are delighted to be participating in shaping how competition law ought to be understood, and in particular, as you said, the colonial legacy. I encourage everybody to also read all these articles. Hers is really very great in showing the direct colonial relationships in the creation of markets to the current moment, which I think is really very important. So our next paper is by Fernando Saldivar. He'll say who he is and about his paper, Another Entire Dimension of IEL.
Thank you, James, and thank you, BC. Just at the outset, I wanted to say to the both of you, thank you, a very heartfelt thank you, but also congratulations. I'm just sitting here hearing what my fellow authors have to say, and what I can't help but thinking is just what a tremendous blessing this is. And in a year like this, with everything going on, everything that is still going on, to at the end of this year to be able to say in triumph, you did it. This is happening. And it's one of those glimmers of hope that we will continue, that the work that we're all so passionate about will continue. And you two are beacons of that. And it's I can't think of two scholars that I'm more proud to have had the opportunity to work on this project with. So I look forward to many more collaborations, but on this one, both of you, a very well-deserved congratulations is in order. On that as well, I'll introduce myself first. I'm Fernando Saldivar. I'm the Global Policy and Advocacy Officer for the Jesuit Justice and Ecology Network Africa, which is based in Nairobi. And the title of my article is Africa in the Economy of Francesco, Rethinking the Ethics of the International Financial Order at the Intersection of Tax Justice and Catholic Social Teaching. And, it's a little bit maybe on where this fits into the conversation and that we've all jumped right into, in that what I propose to do and hope to make a small contribution towards is introducing really to a broader audience the idea of the Catholic Church and of Catholic social teaching as a conversation partner, as a dialogue partner in all of this work, as somebody not necessarily to stand, from the parapet and shake their finger at everybody, but as somebody, a body that's really open to critique, that is well aware of its history, that is well aware of the pain that it's caused in so many different ways, well aware of its role in colonialism, in ongoing neo-colonial structures, and saying that we're open to change. And I know some people may hear that and think that that's not the church that I know, but what I offer to you is that that's in fact the church that's developed under Pope Francis. Even though Pope Francis is not the first pope to critique on rather strong terms the ethics of the global financial order, the manner in which he's done it is unprecedented. And I think part of that, and I discuss this in the paper, is his own background. One point that's often forgotten is that Pope Francis is the first pope from the global south. And that comes with a perspective that no other leader of the Catholic Church, not just in the 20th century, but, has ever brought to this office. Somebody from the margins, somebody from an area of the world that deals with its colonial history on a daily basis. You can't help but open the Financial Times and see Argentina excoriated on its pages every day for, you haven't done this, you need to do this, X, Y, and Z. And as somebody who brings that insight into how he's developed Catholic social teaching on the economy, and that the framework under which this has taken place, is the way it's developed, is into something which is now known as the economy of Francesco, the economy of Francis. And it really is an invitation to radically, and I don't say that word lightly, to radically rethink the foundations of the global financial order, to rethink the ethics on which it is based. And how I propose in this paper to enter into that conversation is through tax justice, is through looking at how what Catholic social teaching is saying right now on the economy and how that can affect the discourse on the ethics of international taxation as applied to Africa. Because I know as many, if not all of us know, that with the Pillar 1 and the Pillar 2 conversations going on at the OECD, this is happening. The powers that be are discussing the very foundations of the international tax system. And I think it's important that, one, that an African perspective is presented, but two, that it not shy away from the language of morals and ethics. And I think that's a way that the Catholic Church can be a conversation partner in this. Because one thing that Pope Francis has highlighted in much of his writings on the economy and on the environment, a lot of this comes out of his 2015 encyclical, Laudato Si, on Our Common Home, is that the way that we think about these problems needs to change, that we need to realize that everything is interconnected, that what affects us, or I say us because, as you can no doubt tell from the accent, I'm from the U.S., but what affects us globally, we're interconnected. And COVID has shown us that with its deadly disregard for borders, that we're far more connected than we ever, than than we've given ourselves credit for. And where that comes into play in the way that we think about all of this is that that's also a call for interdisciplinary work, for interdisciplinary solutions. So even in this regard, my training is as an attorney. Before I entered the Jesuit order, I practiced law in Los Angeles. So in a way, you know, the perspective that I bring to this is merging a legal normative analysis with the ethical and moral and theological framework that comes from Catholic social teaching, and that we not shy away from that. You know, we not shy away from entering this conversation, critiquing and being critiqued. So my hope is that this paper is a small contribution to opening the door wider to your scholarship, to your insight, to your collaboration, because I can sit here right now and tell you that there's a hunger for that right now in the Vatican, for hearing from Africa, for hearing from African scholars, and for being challenged. And it is indeed one of the, if not the, policy priority of Pope Francis as we collectively think about what the post-COVID world is going to look like. And this, I hope, is a small contribution towards that. You know, one of the plugs, perhaps, for jumping into this paper is that I do provide an overview of what Catholic social teaching on the economy has said in the years since the Second Vatican Council, since the 1960s. So again, it's a very approachable way for people that aren't familiar with this to read it, to see if they have questions and how they'd like to engage it, but also, as I can't underline that enough, an invitation. Challenge the church, join in, help us join into this conversation and help us bring this perspective, this desperately needed African perspective, precisely into the rooms of the powers that be. And admittedly, the Vatican is one of those rooms. And hopefully this is a contribution towards that end. So again, congratulations, thank you, and I look forward to continued work with all of you.
Thank you very much, Fernando. It's been great. I think I must say now I feel relieved, James. You know, when I was invited to speak first, I was still very heartbroken that my paper was rejected. So it's great to know it's included in this volume. But it's a great pleasure to introduce yet another great paper in this volume. I think something you would have seen, quite apart from the theme that James mentioned of pairing senior scholars, if you like, they are senior, and upcoming scholars, is that there's a deliberateness to bring in practitioners in conversation with academics. So that we're just not in our own bubbles. And so Nanga Kamau, who does a great work, let her introduce herself, gives us the next treat. Thank you. Over to you, Nanga.
Thank you very much, BC. When I accepted to say a few words when James and BC announced this launch, I promised that I would not be like those politicians or relatives who say, I don't have much to say, and then proceed to detain you for half an hour. So I will try and honor that, and I will say really only three very short things. So the first thing I want to say, and it's an obvious one, is to thank and congratulate James and BC for this effort. I think we can keep saying it this afternoon, and it will not be enough to really note the remarkable work that they have done to achieve this project. And this project really stands out, not just because of the subject, but really because of the heart. And I think Bissie's earlier words and his reaction demonstrate that quite clearly. And what also demonstrates that is the people that have shown up this afternoon. At short notice on a Friday afternoon, evening, people have really shown up to celebrate this. So just that to say that this is a work that we recognize and celebrate, and I look forward to the success of this journal. Now, the second thing I'd like to say is about the topic and why the topic is important to me. So the topic you will see is on reform of investment laws and treaties. In Africa, this is a topic that's been occupying states around the world and no less on our own continent. It's an important topic because it talks about, it relates to how states and investors interact with huge implications on the design of the system and on the implications for states in terms of their ability to regulate, the impact of that regulation, and of course for investors, for their ability to invest in different states and how comfortable they feel investing in those states. And it matters to me because there has been, I believe, a sort of a being left out of African states out of the conversation. I don't know that I put that elegantly enough, but I hope it makes sense in that historically, African states have not been as engaged in the conversations about designing this system as they should have been. And now is an opportunity to do that. And I want, as an African citizen, to ensure that our states are not left out in this round of discussions, in this round of redesign. But in that commitment, we need to be alive to the challenges of participating in that process and to think about how we participate in that process collectively as states and individually as states. So that's really the focus of my piece. And I'm not going to tell you more because I actually want you to read it and then get back to me. But the important thing is that the topic matters, and it matters to me as well. And also it matters now because of the African Continental Free Trade Agreement. So states are engaged in negotiations on the investment protocol. These very questions about the content of that protocol, about the rights, the balancing of rights and obligations between states and investors is precisely what states will be discussing. So that's important. And it's also important now because of COVID-19. So the impact of the pandemic on economies across the world, and more so across Africa, mean that there's going to be a competition for foreign direct investment in the coming months and years. And that will clash, I believe, with states' commitments to ambitious reform. So that's a space to watch, and it's a space that we need to keep engaging in, because at the moment when a state needs to decide whether to accept foreign investment on X terms or on Y terms, or to tighten the rights that it gives to investors, really the need to recover from the economic crisis is likely to take precedence to kind of much more ambitious ideals about what reform should be about. So that's the second thing. The third and final thing is to say what I hope that the piece will accomplish. And I hope that you will read it and that you will enjoy it and that you will learn something. But more than that, I hope that it starts or continues this conversation in this community and beyond. And that also that it inspires us to debate. I'm a big fan of the medium of debate because I think it allows us to test our ideas, to refine our ideas. So I hope that when you read it, you will be inspired to send me a note either agreeing or disagreeing with me, and that you will continue the conversations in written form, in discussions with your peers. And above all, that it will allow us collectively as a community that cares about Africa to engage with these conversations with our states, so that like elsewhere in the world where we see that these conversations are happening between government officials, academics and practitioners, that we see exactly the same kind of conversation happening across Africa, that it's not just academics speaking to each other, practitioners to each other and governments to each other. And with that, I know I've abused my minutes, but I thank you for listening, and I look forward to engaging with you in the coming months. Thank you.
Well, thanks a lot, Ndanga. It's great. I say again to have been part of this very important piece, and as you've said, it is one that we hope everyone engages with, and even with you as well. Okay, so we're moving on swiftly, and the next one is another very interesting one. This time around to one of the editors of AfronomicsLaw.org, Dr. Titilayo Adebola, who I would also just abuse this process to publicly say a huge thank you to you for all the important work you do, and for those late night calls, being in the UK and speaking with James and I in North America. We really appreciate that. But another quite seriously groundbreaking work in the intellectual property realm, which I'll let Titi speak about. Over to you.
Thank you very much, BC, and thank you, James, and thank you to the AfronomicsLaw, the ORG team, for this excellent addition to the platform. It goes without saying that we can't just celebrate all of your hard work and all of the collective effort in bringing this journal to life. So I would say thank you very much again for that. So my piece is on a topic that is very close to my heart, intellectual property rights and intellectual property rights in Africa. It's titled Mapping Africa's Complex Regimes Towards an African-Centered AfCFTA Intellectual Property Protocol. In conversations that I've had over the past 2 years, we've talked about how intellectual property rights in Africa is fragmented. We have sub-regional intellectual property institutions that have different disparate intellectual property provisions. And then we have different sort of policy frameworks and instruments at the African Union level. And the question, one of the main questions that came to the fore was how do we connect the policy aspirations, especially with the Pan-African movement, and thinking about having one African-centered voice of intellectual property that is development-oriented with the practice on the ground at the sub-regional levels. And one of the main sort of issues that came to the fore was that there was a disconnect, a sharp disconnect to what was happening at the regional level, at the international level, and then at the sub-regional and national levels. So at the regional level, we have the some instruments like the African Union module law on local communities, plant varieties, plant breeders' rights, which is the groundbreaking work of Professor Johnson Ekpere. And we see that this instrument that stood as an example of what Africa could produce as a counter norm, as a counter regime to some of the mainstream plant breeders' rights regimes like the International Convention for the Protection of New Varieties of Plants. We saw that no African country was taking this up. And one question was, why was this the reality on the ground? And like other forms of intellectual property, we see that there's lots of pressure, coercion through trade regimes. So one of the things that I would want my work to show would be to see that we have established instruments, we have established policy frameworks at the African Union level that the sub-regional organizations can draw on, and especially now with conversations about the AfCFTA and the Intellectual Property Protocol, I think this is a time to reconfigure or to rethink how intellectual property rights can work for Africa in line with what the African Union's development-oriented agenda was. So that was sort of the primary context around which I drew on the work, and I'll leave you to read it and hopefully get feedback. But I would especially invite policy makers and the IP negotiators to read the work and hopefully get some inspiration on how to redraw our IP framework on the continent. Thank you.
Thanks a lot, TT. It's indeed an important piece in this inaugural issue. So we'll move on swiftly, not to a certain BC, but to Amaka and Soteng, who together are also very important members of the team that's put this together. And so Amaka, I guess you have the floor to speak to your own co-authored piece.
Hi, everyone. Thank you so much to BC and James for the journal and just pushing through, because it's been hard, and knowing you guys, your schedule, I don't know how many hours in the day BC and James they have, because I don't think it's the same 24 hours. So basically what Sotang and I did in this particular piece is to just summarize what has happened so far on regards to IEL and Africa. Like James mentioned, there is really not much written about what is going on within the continent, the impact of these activities on IEL governance and scholarship and development within the continent. So what we did in this piece is to basically show or analyze what has happened so far. So we discussed the trade agreement, AfCFTA, we discussed the Kenyan-US trade negotiation and what that means for Kenya and East African region. We discussed also the border closure, especially in light of the AfCFTA, in the sense that Nigeria closed its border, but at the same time, it has again signed onto the African Continental Free Trade Agreement. So if an issue of border closing comes up, what does that mean for the larger practicalities of a continental trade agreement? We also discussed the African nations' first activities in regards to the DSB and what that also means for IEL jurisprudence in Africa. So that was basically what we did, just mapping the scenes of like African participation and involvement with regards to IEL scholarship and IEL governance. Thank you. Sotang?
Hello, everyone. Can you hear me?
Yes.
Yes. Okay, great. I first want to start by thanking Amaka, it was a pleasure really to work with you this year. The support that you gave and sharing the ideas with you, I really learned a lot. And I do also want to thank James and VC for allowing me to be part of this wonderful project. And ever since James did share his concern about the dearth of information on Africa's participation in international economic law, I was an immediate convert to the mission. And I've learned through the process of doing this research that there's so much that Africa is doing, not only in terms of participating in international economic law, but also in creating and in developing this area of law. And I will just highlight maybe 3 of the things that you can find just as an appetizer in our work. We talk about how African countries are utilizing the WTO, especially the exceptions that are provided in the regime. And we do a case study of safeguard measures that have been implemented by Madagascar, by South Africa, and by Morocco. And the takeaway from that is that African countries are making use of protective exceptions that are provided under international instruments so that they can protect their economies from injury. We also discuss a landmark case in the WTO. It's a landmark because it is a precedent, because it's the first time that there's been a panel established in a dispute between 2 African countries, being Morocco and Tunisia, where Tunisia was arguing that anti-dumping duties that were levied by Morocco are contrary to the anti-dumping agreement and to the GATT. And we also discussed one of the most interesting developments in 2019, which was the US-Kenya Free Trade Agreement. And we discussed what that could potentially mean, not only for Kenya, but also for the East African Community Treaties and also for the African Continental Free Trade Agreement in terms of its mandate of trying to boost inter-African trade. So that is an overview of some of the delights that you will enjoy in our piece. Thank you.
Thanks a lot, Amaka and Sotang. And I think it's particularly important to highlight the fact that even as top of the article is clear, and Mariam's piece on the gendered and gendering nature of IEL, I think we must not lose sight of the fact that many women are producing important work that I hope everyone engages with, right, as the authors have shown. Amaka and Sotang have not only co-authored that piece, Amaka has at least 2 books, one out, one on the way. of critical importance to the continent. TT zone is coming. Clear zone is out there. So really, I think for as many of us who are in this, thank you for spending your time here with us. That is one part of the piece, to engage with the thoughts of these women who are delivering a lot for us to really work with. So thank you very much again to both of you for this very important overview of development in international practice in Africa. So another one, which is the next piece, we'll have Harrison come on for, really shows an aspect which, to use James's, one of his titles, underappreciated jurisprudence of Africa's international courts, or courts, right? It's one of those ones that, you know, people have just thrown to the side. Although now they are, seeing it and seeing that these courts exist for very important reasons, that we just need to peel the layers beyond what we are probably comfortable with in the dominant literature. So with that, I'll call on Harrison Mburi to speak to his very interesting article.
Thank you, BC. Thank you, Prof. Gathii, and everyone, and congratulations to my fellow authors, and to James and to BC. And I agree with Amaka that you guys have, incredible energy. I mean, this year has been difficult, but you've pushed us to produce this. I mean, I personally was pushed off the cliff to make this possible. So I thank you for doing that, because academic writing is not easy. For this case note is not a usual case note, because it's very detailed. You will realize it's just 2 cases. In fact, I was to do 3, but if you're interested in that, this is a sneak peek of my PhD thesis that, God willing, will come out, when my supervisors decide. But I want to say that these 2 decisions are very important. First, because the PHE versus Uganda decision is the first decision in the ESCJ that is dealing with a purely sort of economic issue, and that is tackling questions that are dealing with, you could say, commercial issues. Because the ESCJ, for those who have followed it, has been dealing mainly with, human rights, rule of law, issues that are not necessarily related to integration or to international economic law. So this case is groundbreaking. And because most of the time, these kinds of cases are not showcased in mainstream international law, and that is, using Thuo language, then you might not even be aware that this case was decided. And that is why this journal is important even at an inaugural level, because then you have a decision that is coming out of a court that is important for very many reasons, but like BC said, is not just underappreciated, but marginalized. So part of this process is to say that this court is actually producing jurisprudence that is important for international law actors everywhere, and that's important. And if you listen to James's Grosch's lectures this year, part of the discussion was that Arusha is also producing important jurisprudence, and this is part of that jurisprudence. Then you go to Ohada in West Africa, and not only do many people don't even know that this court exists in the first place. We don't know that there's a court in Ohada that has been churning out many cases. This is just one case. I just picked it because it has this interesting aspect where these arbitrators decided that they wanted more money. In a real sense, they had been given money that they were supposed to get under the Ohada rules, but they looked at this case and they said, we're not getting enough, and they said, we want a little bit more. And this case then spiraled into a big case, because then it was also going on in ICSID, and then it went on to the US District Court, and it's just interesting. So read my piece. Thanks.
Thanks,
Thanks a lot, Harrison. I'll hand over to Jane.
Sound like you have a really tough supervisor. So the next paper is the one that threatened to be the weak link, but after sleepless nights, it showed some promise. So over to BC.
Okay, so thank you very much, James, and thanks to indeed everyone for agreeing to include this paper. This is an article that the time was and remains close to my heart, in the sense that development question, as some of the other articles in the piece have shown, remains central to Africa's future, present and imminent future. But what development is the question. So if TT's piece has spoken to the African-centered nature, that we need to think about this, well, the other big bucket where many scholars think about development is in the law and development narratives, I would say. I wouldn't say field, because it's a contested area as well. And so that has its own critique and baggage, which, as I argue in this article, I do not intend to import into the narrative that I have sought to develop here. Indeed, what I try to do is to maybe look inward in this article to say, what are the other marginal types of development issues that are coming up or have happened in the continent that we should be thinking about in imagining a future regional economic integration that is development-centered. And so one theme that I engaged with is this notion of developmental regionalism, which I argued has been under-theorized and contributed to the marginalization or failure narrative of African regional trade agreements, particularly in the sense that once you look at these frameworks and they don't map onto what we know in the European, hard to make sense of them. But in that thought, actually, we miss opportunity to reimagine and expand the theorization of these schemes outside of the neoclassical understandings that we have of them, right? So that if the trade core economics contexts work for the European ones, well, if it doesn't work for the African continent, what works, right? And so James, for example, thinks of it in his own work, important work in flexible legal regimes, which we have different opinions in some regards, quite interestingly, with respect to that. But I don't disagree with in its entirety. Claire has a dimension of that too in her own work. But where this has led me, apart from piecing out on the piece, themes that emerge on the table that I have towards the end on the overlapping moments of regionalism in Africa, is really what is left for us in understanding law, really, right? That at the heart of this, law is not a hard ball in this trade agreement. And I went the route of anti-formalist regimes, right? And so if you think about it in that way, it means whether it is economic or non-economic objectives, there's a particular idea of law that follows them along. And they're not one story at the end of the day. So that indeed, thinking through this, whether it's in the context of projects in modern day, as you know, corridors of development, digital trade, rise of public-private partnerships, regional value chains, there are different ideas we need to unpack, quite apart from understanding these themes about what law does or does not do in that process. So I hope people enjoy it, but again, thank you very much indeed to the editors and the advisory board for the opportunity to have this piece as part of this inaugural issue.
Great. I can assure you that that excellent article by BC, the reason that it had trouble was not because there's disagreement between me and him about how to think about African regional trade regimes. And this is a true story. I think BC, you can confirm in real time. But it's also an indication that there's diversity of opinion among people working on this. You know, like Danga was saying, there's so much happening. And I think that we are responsible as scholars, as practitioners, as people who work in this area to acknowledge these differences as we try to develop the work. I think Dr. Debola underemphasized her paper. She's too modest. So let me try and reframe, at the risk of being embarrassed by the author of the paper. Let me, at the risk of being in trouble, restate one thing about her paper, which is she is trying to recenter the debates about intellectual property law to center on the IP themes that are most critical for developing countries and Africa in particular. And I know this is the work that Amaka Vani has been doing among other scholars. This is really foundational work, but I encourage Titi and Amaka not to cede the territory and to claim the territory. I'm super proud of both of you because you guys are producing work that is not being produced elsewhere. And, you know, I think I can say this with confidence that both your forthcoming book, Titi from OUP, and your award-winning book, Amaka, are really changing the conversation. And part of the mission of this journal is to make sure that other people don't write the narratives about these areas of international economic law, and that we take responsibility and we take pride in the work that's being done by these younger scholars. Just like Vela's work and Taimon's work on competition law and all the work really in this journal, we need to claim this space and not apologize. So I apologize to you, Titi and Amaka, for sort of saying what I have said, but I think it is really important to make these interventions at the level to which they belong. They are not footnotes, they are not adornments, they are not decorations. They are really central to our understanding of the discipline. So, you know, I want to give, in particular, Titi the right of reply, because I may have completely sort of characterized her work, and maybe that's a record that we need to erase.
Okay. Thank you very much, James. Thank you, BC. Thank you, everyone, for all the excellent comments and overviews so far. So, James, you're right in stating that I emphasized some of the intellectual property rights subject matters that I felt that are most prevalent and are most beneficial to Africa. So some of those intellectual property rights would be geographical indications. That is one area of intellectual property that Africa has a competitive advantage and a comparative advantage. So for example, Miriam talked about Adiwe. That could be an example of a geographical indication, and that is from a particular location in Abeokuta, southwest Nigeria. And I think those are our strengths. We have pockets of those examples of products, food products, clothing materials, and handcrafts. We have paintings, all from different areas around Africa. And I think that is one of the strengths. The other strength that we have is traditional knowledge. So we have a wealth of traditional knowledge for plants, for medicines. And I think that that is another area that Africa needs to emphasize. And that is an area that Africa can define the scope of the legal frameworks, because at the moment at the international level, there are conversations about how to frame traditional knowledge. So we have ongoing negotiations at the World Intellectual Property Organization Intergovernmental Committee. And this is one example that if we don't have agreement at the international level, Africa can actually set a template of what a traditional knowledge framework can look like. And we've seen examples of that. Intellectual property rights are not scientifically derived, they are constructed. And we see that as a localized globalism, with Santos's argument that every form of globalized intellectual property actually started at some national level and they have been transported. So we take the example of geographical indications, we see origins from France. If we take examples of plant variety protection, we see origins from the United States. So let us take an example of traditional knowledge and let the origin be Africa, and Africa can define what the scope would look like. The third example, so I've said geographical indications, I've said traditional knowledge and traditional medicines. The third example will be plant variety protection. I think that is the work that Professor Ekpere has done. And what happened with that was at the international level, we also had debates around what plant variety protection should look like. And we see origins of a particular system, so the UPOV system that originated from Europe, and that has sort of proliferated around Africa. But we see some counter-hegemonic responses. So we see examples from India, we see examples from Thailand, and we also saw a powerful example from Africa with the Africa Model Law, and that is one groundbreaking law that I think that the rest of Africa should begin to incorporate at the domestic level and to resist the forms of pressure to join the UPOV styled law. So that would be the third form. And I think at this point of the AfCFTA, that the negotiators can draw a blank sheet and decide on how to design or craft the intellectual property law framework in a way that would reflect the strengths and the realities on the continent, and to push intellectual property rights as a form of response to the knowledge constructions and to the knowledge systems that we have on the continent. So that would be the point on, that would be some of my points on intellectual property rights. And the other point I wanted to make was that there's a disconnect between what happens with our research and what the law and policymakers. I think Africa has a wealth of world-class intellectual property scholars from all over the world, and the reason why the AfCFTA would be an important instrument and the IP protocol would be that during the Uruguay round, we could still see the global south pushing, and we could see responses with, for example, 301 from the United States and countries then declining. But now we have our own instrument that we can sort of present in a way that would suit what the African context would be. So I don't want to state sort of the whole paper, but I thought that this was going to map. So what I've done was map the whole context and the whole landscape of intellectual property rights in Africa. And I hope that policymakers can, because I know that at the moment they're just training processes for the negotiation. So I hope that policymakers can start with these. And intellectual property is an interest-driven subject. So it means that countries can align on a particular subject but disagree on other subjects. So for example, the United States and Europe would align on a subject like plant variety protection, where they both agree with the UPOV system, but the United States would not agree with Europe on a sui generis form of geographical indication system. So the United States maintains trademarks while the EU wants stronger protection. And here we see the EU aligning with Africa and Asia on geographical indication. So I want African policymakers to understand the interests that center or that drive intellectual property normative frameworks, and to then decide how to align in these subjects. And the last point would be that I think that we should have networks that are funded by the continent, because if you're funded from outside the continent, then it might limit your policy space in how you're going to draft your laws. So I would encourage the African Union and policymakers for the IP protocol to have internally generated a revenue to decide on how to frame the IP protocol. Thank you, James, for the invitation, and I hope I represented this well enough. Thank you.
Well, you can all see there's more there. So I'm glad that she had the opportunity to say that. So thank you so much, Titi. So we are coming to the end. So thank you so much for staying with us. On behalf of the advisory board, Anthony Angie, whose time is past midnight in Singapore, has decided to say something. This is a third world event, so he didn't have much notice after that. Another of our advisory board members, Franz, is going to say something, and then we'll be closing up. But everyone is welcome to stay on if you'd like. So, Tony.
Well, thanks so much, James. Am I unmuted? Okay.
Yes.
So, so thanks so much, James. Well, as James mentioned, I did not have much notice of this opportunity to speak, but let me say just a few things, and thank you for the opportunity to speak, James. Of course, being interested in the history of international law, I can't help thinking of another occasion on which trade and Africa were the central topic of the discussion, and that, of course, is the Berlin Conference of 1884-85. So I feel really moved, I have to say, about this particular project and this journal, which is Africa Speaking, presenting its own vision, inspiring us in Asia and much more broadly. As Titilayo pointed out so eloquently, there's so much we can learn from Africa, and there are so many different initiatives that are emerging from Africa. So I see this really as an evening of reversals. In other words, I'm on the advisory board, but in fact, I'm here to learn, because it seems to me that there's nothing I can advise all of you on, because this is a really unique project in so many different ways, not just in terms of the richness of the scholarship. I mean, there are so many wonderful themes that even the presentations made me begin to think about, Africa's response to the debates on investor state, on ISDS, for instance, the different approaches taken in South Africa and so forth. So even within Africa, there are so many different and rich varieties of responses. Africa with South Africa withdrawing, and yet, I think, there are BITs within African states themselves. That wonderful presentation about the Caribbean, and I couldn't help thinking, going back to Eric Williams. So I've got to read those articles, basically, so I've got to find out more about all these things. But, it's really extraordinary, not just in terms of the actual content. And I could say something about each article and why I find each of them so interesting. So I just had to read those articles. But I feel what's really unique about this project is the form it has taken and the passion and the motivation that has inspired it. I think that is as unique and as original and as important. The way in which you all went about doing this and making it freely available and giving this space to scholars and creating a different paradigm in terms of what we should be attempting to do as scholars. Not seeking to publish in the great, established journals, which have their own protocols and their own, you could say, limitations. And I think many of us know what those limitations are. I think many of us have experienced those limitations firsthand. And so I see this as yet another version of what Afronomics has been so amazingly successful at achieving, which is creating a different type of forum which produces a different type of scholarship. So I think those two things go together, not just the scholarship, but the way in which this whole project has been undertaken and the different, you could say, opportunities that it presents. So as I said, I don't speak on behalf of the advisory board. I haven't had the chance to speak to them, but I don't have any advice to give. I just want to say this is amazing. It is extraordinarily emotionally powerful. And thank you so much for including me in this wonderful project. And again, many congratulations.
Thank you.
Yeah.
You're always modest. And now Franz, who is also a member of our advisory board and one of big supporters, one of the people that helped host some of the initial conferences of the Africa International Economic Law Network in South Africa that is really the genesis of a lot of the momentum in this field. And like Tony and many of the senior scholars here, a supervisor of lots of the young tax that are doing great work.
Thanks, James. And I can promise you that I got as short notice as you. And if I would have to say whether you spoke on behalf of the advisory board, we have never met. But I think you did, and I could just say that was it for me. And I wish you all a wonderful evening. Have a glass of wine and whatever you like. And that was it. But I think I can join in saying that it's wonderful to see the developments and that it culminated actually in a journal. I mean, we had a lot of developments. We had everything what Afronomics did, the blog, the network, the conferences, and if we trace it back to the founding of the network in 2011, it's a long way that we have come. And I'm really proud that this journal is of such a high standard. And I think that's very important because very often it's looked down on things that came from Africa, and I can say that because I'm based here and I heard that a lot. And so it's always very important that everything is of high quality and maybe done a bit different. That's true, because it is different and with different priorities. And more than just a book. And I didn't want to make book less worth it, because they are important to create scholarship. But a permanent standing journal, I think, is a real thing where continuously topics that maybe somewhere else are of very little interest, So at the moment, it's extremely interesting that the discussions on essential access to essential medicines come back. They are now so important because everyone needs access all of a sudden. Before, that was mainly a concern of African countries or developing countries and put on the agenda because of that. Now we have India and South Africa trying to waive at the WTO the IP rights, and everyone speaks about it. It's not about who has which interest, but that we actually speak about it. Yeah, and there are many issues that are mostly important for African countries, for several reasons. For development, for this reason, which developmental stage they are in, historical reasons, obviously, for the how do you call that without offending anyone? I don't know, but we all know the exploitation of resources and everything. So there are a lot of reasons why there are other priorities in agriculture, priorities in SPS that are different, priorities in export subsidies, and so on. And they have to be addressed differently. And in this journal, they might have a different chance of being discussed. Not that they that they would be analyzed differently because the law is the same law, but they are discussed, that they have a platform, and I'm very happy that it came to that, James and BZ. I know it's not just James and BZ. I know that there are many involved who contributed to that, but at least you always kept on going and pushed the others to make it work. And I'm very happy to be on the advisory board, but as I say, I feel very senior and very old when you actually say that, I must admit. So on that note, I wish you all the best. I know I'm in the second edition actually, and feel very bad because I'm behind. Good luck with everything.
Thank you so much, Franz. I'm sorry for the short notice. This is the Afronomics way, as you know. I want to put Chris Givers in trouble because, as one representing the audience out there and also based in Africa, if I don't know if he's in a situation to say something for 30 seconds.
We say hi everyone. Sorry, even by Afronomics standard, that's a pretty short notice, James, to say something. But I'm happy to do so. Let me say firstly, just to mirror what's been said before, how excited I am by the prospect of what's to come. I've had a look at all the articles. I don't know if it's just kismet, but so much of what I've been thinking about lately, questions I've been asking myself as I turn towards the world post-COVID have been answered already in some of the articles. So I'm really excited to engage with the text. I think it's a wonderful follow-on from James's lecture at the American Journal. In many ways, it sort of profiles the type of work that has been coming out, I think, for some time, but perhaps hasn't been collected together. And I really welcome the opportunity to engage with everyone here. It's bittersweet because I think at some point we would have all maybe seen each other, and it's obviously preferable to do it in person. But thank you, just on a personal level, the intellectual community, the enthusiasm, the passion, the silent but important political commitment that underlines so much of this work, I think, is welcome, particularly at this time of disconnection. So I just want to echo the best wishes. I hope that one day one of my articles might make it into the journal, although I'm not asking for any special treatment. I expect to go through rigorous peer review. But thanks so much for the opportunity on very short notice to say something, and congratulations, BC and James. And I hope this is the first of a range of different journals that will come out addressing different areas. And I think you guys are modeling the way for the rest of us to perhaps to pick up, to tie our shoelaces and take your lead in terms of the things we write about and the ways we write together. So thanks and congratulations, and I look forward to reading the next journals and to engaging with all of you. Thanks, James.
Thank you so much, Chris. And like many people on who've stayed on, Chris's work has really been very important, and he didn't say that he teaches at KwaZulu-Natal. And I know that he's super committed to the mission of this journal and sort of the work, the kind of work he himself is doing to make sure that this work reaches the students across Africa in particular. So, we'll be reaching out to you, Chris, and people like you to make sure that this journal makes its way to every email address of every African student on the continent, because that's our goal. That's really our goal, and that's why I wanted you to speak on behalf of all the teachers of IEL in the continent. I want to take a point of privilege. There's a young man who hasn't turned on his camera. Is Ethan Thuo. That's my son, who converts all the Indabas and even this program. He's going to convert it into a something that we're going to put up on our. I know he's not going to put on his camera, and I'm going to be in trouble after this. So we are not. I don't pay him. He's doing his exams. He called me last night, got 100% in one of his tests. So I'm sure he's super excited. So thanks, Ethan, for all your effort. I know that we can't pay you enough. We appreciate your help very much. So to close this off, BC, so we can have an informal conversation, I just wanted to say, in addition to helping us to spread the word about this journal, that BC is going to say something about the new website that's coming up soon. We have an Indaba that's also going to be released before the end of the year, that was done by our Dr. Adebola, speaking to the UN Special Rapporteur on the right to food. Michael Fakri is going to come out soon. There's going to be a symposium that you don't want to miss on the US-Kenya FTA that's going to come out maybe before the end of the year, because we think that the transition moment in the United States is a really important moment to sort of participate in the discussion and to preempt anything happening before it's 20th of January 2020. So BC, there you go. Do you want to say something about that so we can close off?
Yeah, I mean, thanks a lot, James. Indeed, you mentioned some of them to thank the folks who are remaining, that this will soon be informal to be able to chat with you. But yes, so I think the big one here is that the website is undergoing a revamp that we hopefully will make it even more user-friendly and cater to the many things that are now on there. And I think one that I'd like to speak to is the African Justice Network, which is another important piece of the work we have undertaken in the past couple of months and will be launched properly in the new year, which is to address a lot of the issues arising from the debt profile of African states. It's a collaborative effort between many civil society organizations in Africa with AfronomicsLaw doing this. So please look out for that in the new year. We do also have 2 important book review symposia coming up. Amaka's book is up there, but there's another one on land reform in Africa, which was published by the African Development Bank, that are ready and will be up to there. We also do, as James said, have the Indaba, which will come out with a very fascinating interview conversation really between TT and Michael on very important matters close to the research they do, but with impact for us all in the global space we are. So James, I'm not sure there's anything I've left out, but I do think we really want to have the opportunity to informally just chat with folks who want to hang out virtually.
Yeah, I think that's it. You know, we are very grateful for your presence here today. We don't take that for granted, and we, like, the big message is thanking the authors for trusting us. Now the journal is up there, it's out of our hands. Don't be kind to us, you know, let us know what we can do better, and spread the word about the journal. We don't have an Oxford University Press or Cambridge University Press brand that is going to persuade people that they need to read this, but I think this audience understands why this might matter. And so we are hoping that you're going to be our ambassadors to make sure that the journal finds its way around, and that you will hopefully, unlike BC, have an easier time getting your articles accepted at some point. Asante sana, thank you.
Thank you so much, everyone. Thank you.